of domestic law, it would be unnatural to read Article 22(3). It would be displace domestic doctrines to displace in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. There has to be a statutory in absence, doctrinal approach will be available in the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. In absence, for example, Article 1 refers to disputes capable of settlement by arbitration, while interpreting, but it does not identify what this interpretation is especially appropriate that matter in the domestic of Article 2. Then, far from similar domestic law, Article 2 provision of Article 2 does not apply the use of domestic doctrines to fill the gaps in the convention. In absence, for example, Article 1 again to will convention requires courts to rely on domestic does not identify the gap. This interpretation does not specially leaving that apprehensive regime that displaces similar domestic law. Article 2 provision of Article 2 does not apply use of domestic doctrines. The only provision of the convention that addresses dear lordships can for example, those again will convention requires courts to rely on domestic does not identify the gap. This interpretation is not leaving that is some regime that only provision of the convention similar addresses the enforcement of arbitration agreement is Article 2(3). We do not read the non-exclusive language of that provision is set as ceiling that tacitly precludes the use of domestic requires to enforce arbitration does not here this interpretation does not leaving that there is some exclusion that while the provision of the convention similar addresses the enforcement of arbitration agreement is Article 2. With your lordship's test, you do not read the non-exclusive language of that provision is set as ceiling that tacitly precludes the use of domestic kindly come and read 17 does not here this interpretation does not some of the parameters which are considered that while examination for your lordship's assist addresses the enforcement of your lordship's pleasure is Article 2 with your lordship's detail or not I may not got the language of that I have set as silly unnecessary time the exercise is what are the parameters 17 by other jurisdictions of the world to incorporate to accept the group of the company doctrine. It's not just not group of the company that somebody is a company and is group company of somebody else. That's not the only thing. Lord, please come to my Lord page 19. Representation, agency and apparent authority. Often theories of agency and these are illustrative. These are not exhaustive. It would depend upon the fact-specific situation. Often theories of agency and representation are relied upon to bring an arbitration claim against a party who is not signatory or a part of an arbitration clause. Though the exact meaning of the agency and representation is different in each jurisdiction, the fundamental principle is that one party acting as an agent execute a contract on behalf of other party, which will be the principal. Then irrespective of who the signatories are, both are liable. In this kind of scenario, questions have arisen as to whether the principal authorized the agent with categorical power to enter into and bind the principal in the arbitration clause, or the power so conferred was general authority to enter into a contract which is a substantive contract. But most of the case law is on this, that I authorize my agent to enter into a contract, but my authority can be specific. That all right, you bind me even for arbitration, or my authority may be limited. That bind me in the main substance of the contract. If there is a dispute, you two of you settle. That would be fact specific. Variety of situations have arisen under this head. If from the agreement, whether an agreement in conventional sense or an act of agreeing through correspondence or other acts, expressly confers power on the agent to bind the principal, even with regard to the arbitration generally, the doctrine is made applicable and the principal is joined in arbitration proceeding and is bound by its outcome. Now, my lord, some jurisdictions have gone a step further. there may not be any express authority, but a presumed or ostensible authority. Somebody, my lord, gives an impression that I am authorized and the principal doesn't object by his act of commission or omission. Please see, my lord, absence of actual authority in some jurisdictions, the courts are also examining whether a party not mentioned in the arbitration clause should still be bound on the basis of apparent or ostensible authority of the party which is a party to the clause or substantive contract. In the event of a party initiating arbitration against a non-signatory or a non-party, the claimant will have to satisfy two conditions. But these are the broad conditions, my lord, which are generally found in all jurisdictions when it's a question of fastening the responsibility based on ostensible authority. A, the principal had very apparently induced by way of a false representation the claimant to believe that the agent had the authority to bind it in an arbitration clause. B, such misrepresentation can also be implied based on the existence of undeniable and intricate business and corporate links between an ostensible principal and or the ostensible agency, which can reasonably lead the claimant to believe the existence of such an authority. This will again be a subject matter of fact situation in each case. Lord, I can skip, Lord, others. Kindly come to third party beneficiary. Lord, some jurisdictions, my lord, to how far, my lord, this court would accept again would depend upon the fact situation. But if in a contract between A and B, it is explicitly mentioned that it is for the benefit of C, and C has derived some advantage under the contract, he cannot take the plea that he is not a signatory and therefore would not be bound in the arbitration. Then party taking direct benefit. Now, I have given some judgments also. Lord, I don't think, my lord, I should read those judgments, but this is for your lordship's assistance. And we have placed, my lord, the copies of the judgment, my lord, if your lordship considers it at your lordship's, my lord, leisure to read. Then, my lord, incorporation by reference. My lord, I am not reading it. I'll just generally give the overview, my lord. There are judgments, my lord, which I have cited in the footnote. My lord, in some jurisdictions, what happens is a contract is between A and B. C is completely alien to the contract. But the contract refers that for the performance of the contract by A with regard to B, C has by later dated so-and-so agreed to do this. C has by act supplied something. C has by his act purchased something. So, my lord, in fact situation like this, incorporation of responsibility even by implication or reference made in the agreement with regard to a party who is not a signatory to the argument, that is also, my lord, accepted, and that is also, my lord, an extended group of company doctrine. Then your lordships may come to 24, doctrine of single economic entity. My lord, the case of discovery which my lords decide, where the registered office of the company and the subsidiary was on the same place, the chartered accountant was same, several things were being done together, one was representing other and other was representing one, my lord, respectively, etc. Then, my lord, parameters, my lord, which are, my lord, if your lordships can quickly go through 24 bottom. My lord, these are examples. Basically, my lord, as I say, my lord, these are illustrative lists, cannot be an exhaustive list, my lord. But there are several, my lord, illustrations I have given. Then, my lord, since I am not wasting their time, my lord, I am not going into it. Equitable estoppel doctrine, single employer liability, controlled group. Lord, there are several facts which emerges before your lordships. That this is controlled by this group. This is just money going from right pocket to left pocket. Then also, my lord, it has done. Then economic realities tests. There are some judgments, my lord, on that, where group of company doctrine is applied, joint employer doctrine, etc.
Yes.
Now, my lord, what would be last, my lord, my submission? What would be the contours? My lord, suppose your lordships were to hold that as a doctrine, group of company doctrine is accepted. At the stage of section 8 or at the stage of section 11, what extent your lordship's examination would be. My lord, earlier there was a 7-judge bench judgment, that is, my lord, SBP and Company versus Patel Engineering Limited, page 32, my lord, and I have quoted.
Yes.
I am not reading it for a reason which will come subsequently, my lord. My lord, here it was, my lord, pre-amended situation. My lord, kindly, my lord, take this a little, my lord, kindly consider this. My lord, prior to the amendment, my lord, the Chief Justice or his lordship's designate under section 11(6) was supposed to look at only the existence of arbitration clause, nothing beyond that. This judgment of the 7 honorable judges of this court was based on the earlier law. Thereafter, the law changed. And, Lord, a little wider jurisdiction, my lord, now is available with the Honorable Chief Justice or his lordship's designate lordship. Now, kindly come to para 35. After that, my lord, Vidya Drolia comes. And it says that now, in view of the amendment in the Act, namely section 11(6), this Patel Engineering is not an applicable law. It could not have said good law. It's not an applicable law because of the change of law. And, my lord, this judgment, my lord, subject to, my lord, being pointed out contrary to this, my lord, holds the field today. And I don't think, my lord, there is anything which can be objected to. This is the test laid down. Lord, it's a 3 honorable judges. Justice Khanna wrote, Lord, the majority view, and then the Honorable Chief Justice, Lord, wrote a concurring supporting. May I read, my lord, or leave it at that?
That's okay. I think we can go on.
Yeah.
Lord, I have also, Lord, given that, my lord, and my lord, I have also said that apart from section 8 and section 11, another stage is section 60, where, my lord, this issue can be raised and can be considered. Only last argument, my lord, which is not a part of my written submissions, but in the morning, my lord, I could think of it. Please come to section 28, my lord, and I'm done. I'm not referring, I'm not, my lord, repeating anything. 28. But the group of companies doctrine has its root in equity, because your lordships do not desire multiplicity of litigation and one-stroke dispute resolution solution under the arbitration clause. And your lordships can evolve that doctrine, that's the submission, rules applicable to substance of dispute. Lord, please see 2. The arbitral tribunal shall decide ex equo et bono or as amiable compositor only if the parties have expressly authorized. Meaning thereby, this restriction that you cannot have any doctrinal approach is not restricting arbitral tribunal's jurisdiction, not your lordship's jurisdiction. Your lordships can say that this doctrine is the doctrine which is in furtherance of the intent of the Act. And 3, while deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable. Your lordships are also, my lord, while applying doctrinal approach, not bound by the terms of the contract.
Suppose we say that the arbitrator shall decide.
Then
what happens?
No, my lord. Then also, kindly see me. He will go by, my lord, the trade, 3, trade usage. That yes, in this particular trade, this is perfectly usual. Lord, really speaking, the tribunal would decide that issue, not under 28, but under 16. Under 16, whether there is an arbitration, whether we have the jurisdiction on the arbitral tribunal's jurisdiction. Here, the tribunal would be bound by a lordship's doctrine, because that's the judicially evolved doctrine, and not bound by the terms of the contract. Lord, these are my respectful submissions.
Thank you, Mr. Solicitor.
Lord, I have given, my Lord, the judgments and, my Lord, some special which we found, my Lord, to be useful and, Lord, assisting your Lordships, which is already filed. I'm not reading it. Your Lordships can, my Lord, if your Lordship feels, just glance through it. It would, my Lord, assist the court, my Lord, in arriving at it.
Thank you, Mr. Solicitor.
Lord, immensely grateful, my Lord, for the inquiry. Lord, would your Lordship, my Lord, I'll just place, my Lord, that file,
Sorry,
the file of the Law Ministry, your Lordship,
not necessary, I think.
to them and thereafter, my Lord.
Not necessary.
Please, your Lordship.
Will be adopting the same line as the solicitor or?
Not exactly, my lord. I'll tell my lord broadly the line I'm adopting.
Your Lordships can pardon my absence for some time, right?
Now, Mr. Kambata is going to argue, then Mr. Ritin Rai, right?
Yes.
That concludes everybody.
Mr. Devan is, I think, also there.
All right. How long would you take, Mr.
But I would take about 2 hours. I'll try and
About
curtail it.
2 hours.
Try and curtail it. I put my submissions
All
in
right.
writing.
And Mr. Rai?
Lord, I've been through Mr. Kambata's submissions. I have something to add, which I've also put in my submissions, my Lord. I had anticipated, my Lord, 2 hours myself, but I'll take much less than that. Lord.
Okay.
But
So that means it will not get over today.
yes, my Lord, because I have some differences from
What
the
Mr.
other-
Kambata is
but
arguing.
even to
So today, probably Mr. Kambata will get over today.
yes.
Look,
And then we can keep this thereafter just to keep the format and the time schedule on the 11th because
Yes,
10th is the miscellaneous
Opening
day.
day.
Next week we have 2 days which are going to be miscellaneous.
Miscellaneous.
10th will be miscellaneous. Then 11th we can take we can hear Mr. Rai for the morning session.
Yes.
Morning session you can wrap up. So then we can conclude
The other
the
side.
matter by the morning session.
Tomorrow is also, my Lord, miscellaneous.
Tomorrow is miscellaneous because day after is a holiday. So.
We're grateful, my Lord. The break is a bit unfortunate because it breaks the continuity. for
Yeah,
you.
absolutely.
We're grateful.
So,
My Lord,
so
generally it is said, my Lord, that never give lawyers an overnight to think. The arguments are always lengthened.
which is why it's good everyone's put it in writing.
But, Alison, you got your compilation and your written submissions also.
We filed it.
So then you can just take us to navigate us.
I will do that.
We'll come back at last. Had an administrative meeting and
No,
that
we
just
understand.
spilled over a little bit.
We fully understand that.
My colleagues were actually waiting for me, but I had to hold them back as well.
Your lordships are all under, there's no necessity to even say that.
Just before Mr. Khambata begins,
Yes.
because I believe your lordship was looking at some kind of time estimate. Now, fortunately for me, Milord, some parts of whatever I have given in my written submissions is also part of Mr. Khambata's submission, so I can certainly skip all of that. I estimate follows about an hour and a half is what I have.
Yes, Mr. Chairman.
The way I propose to go about it, I've heard my learned friend, the Solicitor General, and I've got a full report of what has been argued. And I propose, subject of course to what my lords say, to go about it in 4 buckets of arguments. The first, I think it is necessary for me to go into what the group of companies doctrine really is. And it will be my submission that it is a concept which is founded almost entirely, if not entirely, in the law of contract and requires a mutual intention and an implied consent. It cannot exist outside intention, is going to be my submission.
Mutual intention and
Implied consent of the non-signatory as well as the signatories. Everyone has to consent to the non-signatory being a party. And the second will be that who is a party must ultimately accord or comply with the principles of contract and the provisions of the Arbitration Act. And I will show certain areas where this becomes a little relevant under the Arbitration Act. And it will be my submission there ultimately that the group of companies doctrine will be limited by certain provisions of the Arbitration Act. It's not excluded, but it will be limited. The third is what are the key ingredients of the group of companies doctrine. And there the submission is going to be that all the judgments ultimately seem to say that the object of using such a doctrine is to find someone who is not signed, but who is what they call a veritable party, effectively a party without a signature. That is the object and end result. And without that end result, there's no intermediate person who can be roped into an arbitration. And finally, and this may be the most important for your lordship sitting in Constitution bench, there are 3 or 4 other very cardinal principles which intersect with this principle. And a balancing needs to be done. And what are those principles? The first is that arbitration is consensual. It is founded only on contract. There can be no arbitration outside contract or consensus. The second is the principle of party autonomy. That arbitration allows parties to decide whether they will arbitrate, and if so, what is the scope of the arbitration and who will be involved in the arbitration. So it is extraordinary. It's not that it can't be done, but it's extraordinary to bring in someone who the parties have not contemplated in the agreement. The third is that there are principles which exist in other branches of the law, which would also have to be balanced. For example, the principle which our Supreme Court has recognized in the Vodafone case, that groups of companies are entitled to structure themselves in a particular manner and hierarchy in order to protect themselves from liabilities and obligations. This is an accepted principle of corporate law. And how is that to then be balanced in a given case with the group of companies doctrine? The balance has to be struck so as not to destroy either one or the other of these principles. Now, in this regard, I want to get 3 or 4 things out of the way straight away. I fully accept that doctrinal concepts or considerations can always be introduced into the Arbitration Act. the doctrine of agency, doctrine of estoppel, doctrine of a group of companies. There's no bar to introducing any of these. And it can't be argued that because sections don't expressly provide for them, they can't be. That can never be in any common law statute. That can never be the position. The second, immediately, that a party need not be restricted to a signatory. That also is I think, fairly clear. The third, that in contract law, a party can become a party to a contract, and a contract can arise by conduct. It need not be signed, or even in writing. It can be an oral contract. And lastly, that who can be made a party to an arbitration agreement will be governed by the Arbitration Act, by Part 1, as far as any India-seated arbitration, whether domestic or international commercial. And the solicitor showed us the recent American Supreme Court judgment, which says the same thing, that it's domestic law that will decide who is a party. So this is a very broad framework. And then, of course, I have reached conclusions in my submissions, which I commend to my lords. But I would first like to start with the genesis of the group of companies doctrine. Our Supreme Court, in at least 2, if not 3 judgments, has expressly said that this doctrine comes from an arbitral award. And that is the only reason I'm reading an award before my lords. Normally, one would never cite an award. But since the Supreme Court has recognized that the genesis of the doctrine is from this award, may I request my lords to see the Dow Chemicals award?
The Dow Chemicals, right?
I have filed a compilation which is serial number 11. My submissions are serial number 5, I'm told, in a listing for my lords. And serial number 11 is the compilation.
Mr. Khambata,
Yes.
as you are opening your argument, I was just going to say, you have said that there could be a group of companies identified as a particular group.
Yes.
And you say that companies are entitled to protect themselves from liabilities.
Yes.
So there could be correspondence, there could be intention, which would say that although I am part of this group, yet I am out of any obligation arising out of contract between A and B. So
Yes.
you will have to sort of, because
I will
this
go
is
into
something
that.
which you are projecting for the first time.
Yes, I will go into it.
This is important.
No, I will go into it. And how far can a court go in respecting it? There will be some cases where my lord will say, no, the veil has to be pierced,
Correct.
or this has to be disregarded. I'm not again for a moment suggesting any one of these principles is absolute. There's a balancing to be done. But a balancing has to be done. And what really is happening today, and that is the reason why it's so important the Constitution Bench decides this, is perhaps not in the Supreme Court, but my lords, in the High Courts and in tribunals. The attempt now is to look at a group. If you have an arbitration agreement with one entity, to then look at the entity within that group, which is the most creditworthy or which has the most assets. And sometimes on the most peripheral connection, hardly a connection, certainly not a connection that will satisfy any of these tests, that party is roped into an arbitration in a non-consensual manner. And that is and using the chloro-control principles. Sometimes, of course, disregarding them, but my lords are not concerned with the aberration. My lords are concerned with the principles. And therefore, in any view of the matter, it will become necessary to set down fairly strict parameters. I again accept that my lords should not, down to the last detail, set out a formula. It can't be done. They must leave some play in the joints, because these are matters which will alter from case to case. But certain clear guidance is required. Yes. And I will of course come to Justice Roy's question when I'm conscious of that, of how that can be done. And I'll be placing the Vodafone decision before my lords, where this is expressly raised and decided. The Dow Chemicals case is page 1 of this compilation. Do my lords have it?
Yes.
Just the title first. There were 4 claimants: Dow Chemical France, Dow Chemical Company USA, Dow Chemical AG Swiss, Dow Chemical Europe Swiss. The defendant was Isovo. Now, the first two Dow companies, Dow Chemical France, DCF, and DCC, Dow Chemical Company USA, were not signatories to the arbitration agreement. That is the admitted position. Dow Chemical Company USA was the ultimate holding company of this Dow Group, which of course had many other companies in it, but these were the companies that were involved in this transaction. Claimants 3 and 4 were assignees of the original Dow company that had signed the agreement. And they were also subsidiaries of DCC, Dow Chemical USA. Initially, it was signed by Dow Chemical Venezuela, but it was assigned. So claimants 3 and 4 broadly were signatories to the agreement in the sense that they were assignees. They were claiming through or under. They were not in this broader concept of group of companies. The first two Dow companies, DCF and DCC, actually intervened and made claims in the arbitration against Isova, saying we are also entitled to make claims. This was a case of a non-signatory trying to join an arbitration and make a claim. And obviously, Isova took a jurisdictional objection saying they have no right, they are not signatories to the arbitration agreement. In that context, my lords, kindly turn to page 2. And unfortunately, these are only extracts. We couldn't get a complete report of the award. But all the authorities seem to suggest that these are the relevant extracts. The extract at page 2 on the top, on the sources of law that should apply. The first para, considering it is not disputed that the arbitration clauses relied upon by the claimants are contained in contracts that have been signed by neither DCF nor DCC, Dow Chemical USA, that these two companies nonetheless maintain that they may invoke them by reason both of the factual context of the conclusion and performance of the contracts and of the fact that these companies, along with the signatories of the contracts, are part of a group of which Dow Chemical USA is the parent company, the 3 others being its daughter and granddaughters, entirely controlled by the firm. That is one undisputed aspect. The next is 3 paras from the bottom of that page. The paragraph starting, considering that the tribunal shall accordingly determine the scope and effect of the arbitration clauses in question, and thereby reach its decision regarding jurisdiction by reference to the common intent of the parties to these proceedings, such as it appears from the circumstances that surround the conclusion and characterize the performance and later the termination of the contracts in which they appear. In doing so, the tribunal, following in particular French case law relating to international arbitration, should also take into account usages conforming to needs of international commerce, in particular in the presence of a group of companies. Turning to page 3, and this I'll read in somewhat greater detail. The tribunal, after accepting that the claimants were all part of a group of companies, then proceeds to discuss the involvement of each of these in the actual transaction. So para 2 at page 3, after a detailed analysis of the contract negotiations, the tribunal continued by considering A, the negotiation of the contracts, considering that in point of fact, DCF, Dow Chemical France, at the time of signature of the 1965 contract, as well as the negotiations which led to the 1968 contract, appeared to be at the center of the organization of the contractual relationship with the companies succeeded by the present defendant. Moreover, this relationship could not have been formed without the approval of the American parent company, which owned the trademarks under which the relevant products were to be marketed in France. So straight away you have a finding that DCF was at the center of the organization of the contractual relationship, and DCC owned the trademarks without which you could never have marketed those products in France. Then that this analysis reveals that neither the sellers nor the distributors attached the slightest importance to the choice of the company within the Dow Group that would sign the contracts. It is significant to note that none of the documents produced contains any trace of a discussion on this subject. In reality, all the entities of the Dow Group involved in distribution in France understood themselves to be contracting with the distributor or distributors in France, and likewise it was with the aggregate of these entities that the present defendants' predecessors understood themselves to be contracting. So everyone understood that all these companies were really contracting parties. Then be that is the time of negotiation, the entering into the contract. Then be the performance. Considering that, as has been mentioned above, the distribution agreement of 1965 as well as the one of 1968 designed first of all Dow France for delivery of the products to distributor. Although it has been provided for that deliveries could also be effectuated at the choice of the seller by other subsidiaries of Dow Chemical Company, it is to be noted that in fact, it has not been sustained that this option has ever been used. It has always been Dow France which has assured the execution of the contracts. Dow France, therefore, played in the execution of the contracts an equally preponderant role as it did in the establishment of the contractual relationship. So this non-signatory was the center of the negotiations and played an equally preponderant role in the execution of the contract. Considering, moreover, that for exercising its contractual activities, the distributor necessarily needed to make use of the trademarks belonging to the parent company, Dow Chemical Company, though no special license agreement appears to have been concluded. This situation shows the primary involvement of the parent company in the distribution agreements. The same significance can be attached to the clause, which has already been mentioned, and according to which deliveries could be made by any wholly owned subsidiary of Dow USA. The clause shows, in fact, that the parent company was the pivot of the contractual relationship finally established between certain entities of its group and the distributors. Then the third factor, termination of contracts. That it thus appears, as was the case with respect to the conclusion and performance of the distribution agreements, that Dow Chemical France played an essential role in the termination of the 68 contract, which had been substituted for the 65 contract, that all of these factors permit the conclusion that Dow Chemical France was a party to each of these contracts and consequently to the arbitration clauses they contain. So cumulatively, Dow France's involvement in being the center of the negotiations, being the person who actually assured execution of the contracts, and being the company that played an essential role in termination, altogether made it effectively a party, a veritable party. Similarly, the next paragraph, that the same conclusion should be reached with respect to Dow Chemical Company USA by reason of its ownership of the trademarks under which the products were marketed and its absolute control over those of its subsidiaries that were directly involved or could under the contracts have become involved in the conclusion, performance or termination of the litigious distribution agreements. I rely on this para because there's a finding of absolute control. In the Vodafone case, as your lordships have said, that even holding 100% of the shares of a subsidiary ipso facto doesn't lead to piercing of the veil. A legal control is required, something more than a persuasive position. So here there's a finding of absolute control. And then, considering that the defendant adopted the same position in its brief of so-and-so before Court of Appeal of Paris in support of its motion of compulsory joinder of Dow Chemical Company, that the defendant there in fact wrote as follows, where this is Isova, who was opposing the claimant. Whereas Dow Chemical Company, owner of the patents and organizer of the manufacturing and distribution of Roofmate, decided and conceived the modalities of the manufacturing and distribution of the said product, thus engaging its direct liability. So the parent company conceived of all this, the manufacture and the distribution, and therefore engaged in a direct liability. Next page. I'm sorry, the last sentence of the preceding page. Considering that in the circumstances of this case, the application of the arbitration clauses to Dow Chemical Company USA may also be justified, as we shall now show, by the fact that the contracts containing these clauses concern, in the context of a group of companies, a parent company and certain of its subsidiaries. The same fact would justify, if necessary, the application of the arbitration clause to Dow Chemical France, then group of companies. Considering that it is indisputable and is in fact not disputed that Dow Chemical Company USA has and exercises absolute control over its subsidiaries, having either signed the relevant contracts or, like Dow Chemical France, effectively and individually participated in their conclusion, performance and their termination. Considering that irrespective of distinct juridical entity of each of its members, a group of companies constitutes one and the same economic reality, of which the arbitral tribunal should take account when it rules on its own jurisdiction, subject to Article 13 of the ICC rules. Considering in particular that the arbitration clause expressly accepted by certain of the companies of the group should bind the other companies, which by virtue of their role in the conclusion, performance or termination of the contracts containing said clauses, and in accordance with the mutual intention of all parties to the proceedings, appear to have been veritable parties. This is an expression that comes from a veritable parties to these contracts, or to have been principally concerned by them and the disputes to which they may give rise. And then in the next few paras, they say that in fact, there were other awards also, where sometimes it was held that these companies in the group were bound, sometimes it was held they were not. And in one award, they noticed it was not, because there was not that level of involvement. And the last para on that same page, in so doing, the tribunal contradicts no principle nor any rule of international public policy, in particular that of the French legal system. The latter is not based on any principle, nor does it contain any rule of such a stature that would prohibit giving to an arbitration clause implicating companies that are legally distinct but form part of a group of companies the scope attributed to it by the present award. To the contrary, by taking into account, in reaching this result, the needs of international commerce to which the rules of international arbitration should be responsive, the tribunal follows the example of French case law, to which express reference was made in the report to the Prime Minister, etc. So the tribunal is very conscious that all this can be done within the matrix of the law, including French law, which govern who are going to be parties to that. Therefore, what does essentially this award do? It said parties who were not signatories, but who were centrally concerned with negotiation, performance, and termination. Parties who everyone considered were veritable parties. The non-signatories themselves considered themselves to be contracting parties. The signatories considered them to be contracting parties. They would be bound by an arbitration clause and could take advantage of it equally, both ways. Here they were trying to take advantage of it. And the signatory was saying, no, I never signed an arbitration agreement with, how can you let them come and make a claim against me? So the genesis of this doctrine is a mutual intention of all parties, signatories and non-signatories. A mutual intention of only signatories is not enough. An intention only of non-signatories is not enough. And this Honorable Court has followed these principles. I'll show that from chloro controls, etc. Now, it is therefore a theory based entirely on becoming a party to a contract, because an arbitration agreement is a contract, by mutual contractual consent. Everyone has consented by conduct. They've not written it, but by conduct and the way everyone has treated it. And then one of the parties can't back out of such a consent, which could be implied constructively from conduct. That is the limited, narrow area of this doctrine. And as a later authority points out, I just want to place that article, that it's a doctrine really that is founded on consent. In fact, the critique of this case is that the fact that it was a group of companies was just one factor. It was really consent that was the main factor. So though the theory is called group of companies doctrine, it's really based on consent and a mutual intention. And I just want to place that article because it's a very good analysis. Please treat it as my submission to your lordships, which is a Professor Hanish's article found at page 152 of the same compilation. It's written recently on 40th anniversary of the Dow Chemical Award. And I'll just point out a few passages. At page 153 of the compilation, the paragraph on the top, about halfway through that paragraph. The para starts with as to the subjective scope of the arbitration agreements, but about halfway through, rather it found that the non-signatories appeared to be true parties to the contracts. It concluded that this was the intention of the parties, both of the claimants and of the companies which were eventually succeeded by the respondent. The arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance, running. The first paragraph.
53, the page begins with circumstances.
I'm obliged. Then the next para is as to the subjective scope.
Correct.
So about halfway through that para, the word sentence starting with rather. Rather, it found that the non-signatories appeared to be the true parties to the contracts. It concluded this was the intention of the parties, both of claimants and of the companies which were eventually succeeded by the respondent. Arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance, and termination of the agreements. Second, it considered what bearing the circumstances that the companies belong to the same group should have in that context. Throughout both stages, the arbitral tribunal focused on the parties' intentions. While analyzing the circumstances of the case, the arbitral tribunal found that both non-signatories played an important role in the agreement's negotiation, performance, and termination. Then the one paragraph after that, starting, it was only after the arbitral tribunal reached the conclusion that the non-signatories were also parties to the agreements, that it proceeded to the analysis of the impact that the existence of a corporate group might have upon the arbitration agreements. In this regard, it is important to mention that the arbitral tribunal found that an arbitration agreement signed by certain companies should be binding on other entities of the group only where the latter seem to be true parties to the arbitration agreement by virtue of their participation in the negotiation, performance, and termination of the contract, and if this corresponds to the party's intent. It's a very important caveat. So it's not that one can just see a group. For example, the Tata Group or the Birla Group. You enter into an arbitration agreement with one company. It doesn't automatically rope in every other company. Or you can't pick and choose. It has to be a company in the same group who has been intimately concerned with all these aspects.
Pivotal role is.
Pivotal role. These are descriptions.
Yes.
I'm not, it's
We can't
not written
sort of
stone.
choosing a particular
Correct.
word, but then we understand the.
Some important role in negotiation, performance, and even in termination if that is the position. Then if we go to the next page, the section starting with no creation of a group of companies doctrine. Over the last 40 years, much has been written. Over the last 40 years, much has been written about the so-called group of companies doctrine, a theory allegedly originated from Dow Chemical case used to bind third parties to an arbitration agreement. However, no consensus has been reached as what should be understood under the group of companies doctrine. Neither its concept nor its contours are clear. An analysis of literature and case law reveals that completely opposite conclusions have been drawn from the Dow Chemical Award. On the one hand, the group of companies doctrine has been criticized and its application has been rejected by courts and arbitrators that considered the group of companies doctrine a non-consensual basis for extending the arbitration agreement to companies of the same group, irrespective of the party's intent. From this perspective, the theory would be a violation of the consensual nature of arbitration. On the other hand, some commentators take the view that consent is at the heart of the group of companies doctrine. They see in it a basis for finding implied consent based on objective patterns. In light of these conflicting views, the term group of companies doctrine is clearly ambiguous. Hence, it is not surprising that discussions regarding the existence and applicability of such theory quite often lack clarity. Not only equivocal, the group of companies doctrine is also a dispensable concept. The idea that the Dow Chemical Award created a non-consensual basis for extending the arbitration agreement is a misconception. As shown above, decisions rendered by Arbitral Tribunal and Paris Court of Appeal actually rely on consent. They did not give origin to a theory allowing the extension of the arbitration agreement beyond consent. And then the last two paras on that page. Furthermore, third last para, I'm sorry. Furthermore, had the group of companies doctrine a consensual nature, it would be only an unnecessary term, adding complexity to what is in fact the assessment of the party's intent. Attaching any consensual requirement to the theory would render it meaningless. Consent is the fundamental and utmost requirement in any case. If there is consent, there is jurisdiction, so that no further requirements would be necessary. In other words, if there is express or implied consent, then the party will be a true party to the arbitration agreement without needing to resort to any theory. This does not only apply to cases where the companies are from the same group, but also where the companies are completely dissociated from one another. The existence of a group of companies is therefore only a factual element that might indicate consent towards multi-party arbitrations. It is certainly a factor to be taken into account when analyzing the parties' intentions, but it is not a decisive element by itself. Consent remains the preponderant criterion. And the last page, 155, conclusion. Dow Chemicals Award landmark decision, it provides clear reasoning as to the fundamental role played by consent in determining the subjective scope of the arbitration agreement in multi-party arbitration. In this case, the arbitrators decided that the companies might be bound by the arbitration agreement entered into by other entities of the same group if the non-signatory companies appear to be true parties to the arbitration agreement by virtue of their involvement in the negotiation, performance, or termination of the underlying contract. Dow Chemical Award did not create a basis for extending the arbitration agreement to third parties irrespective of their consent. In fact, exactly the opposite holds true. The arbitrators found that an arbitration clause might bind a party that has not formally entered into the agreement only insofar as this is in accordance with the parties' mutual intentions. This contradiction puts the existence of a so-called group of companies doctrine into question. In 40 years, the term group of companies doctrine has proved to be misleading and the idea of such a theory a misconception. The fact that two companies are part of the same group does not serve as a basis for the extension of the arbitration agreement on its own. Whether a party can invoke or be bound by an arbitration clause is a matter of consent, which shall be ascertained case by case based on factual elements. This does not mean existence of a group of companies is irrelevant. Quite the contrary, it is certainly an element to be considered in the analysis of parties' intentions, but not decisive per se. Now, I am adopting these as my submissions. And in my submission, when I show chlorocontrols correctly read, it is what chlorocontrols itself has said in many ways. And the only thing chlorocontrols has actually left out is the requirement of performance, which my lords have now added rightly in the discovery matter, ONGC discovery. That fifth element has now come in. But what is important is that these are cumulative elements. It can't be a pick and choose that they're part of a group of companies. It matters not that there's some peripheral involvement in negotiations. That's all. They are roped in because one or two of the factors are satisfied. These are all to be seen cumulatively. And the conclusion has to be reached that with these factors, there's an implied consent and they're true parties. Without that conclusion, there can be no joining of any party to an arbitration because that would defeat another cardinal principle of consensuality. A non-signatory might say, I never agreed to go to arbitration. A signatory might say, I'm sorry. When I show the provisions of our Act becomes very critical. Because our Act requires the provisions of the Contract Act to be complied with. So without consent, you can't have a contract. If my lords would kindly now turn to my note, maybe quicker if I, some portions I will just take from my note. I don't want to trouble my lords to see. Everything is here in the compilation, but if one would kindly go to page 4 of the note, the passage marked common intention. I've referred to the UK Supreme Court decision in the Dalla case. This is a case on slightly different facts because here it was a very odd case, my lords of course know, where award arbitration seated in France came for enforcement to England. England has special laws where jurisdiction is tried de novo in court. by the enforcing court, with evidence being led and everything. So they held a mini trial, and they held contrary to the tribunal, saying, no, according to us, tribunal had no jurisdiction, we won't enforce this award here. 1 month later, the court of the seat in France affirmed the award. So it's that case. But in that case, they had occasion to comment upon what the French law was. And I'm only relying on those observations because they are relevant to our case. So the UK Supreme Court was applying French law to test whether an arbitration clause, this is para 8 of my note, whether an arbitration clause upon which the jurisdiction of the tribunal is founded extends to a person who is neither a named party nor a signatory to the underlying agreement containing that clause. And I quote, the Supreme Court held, whether all the parties to the arbitration proceedings, including that person, had the common intention, whether express or implied, to be bound by the agreement. This was a case where the Pakistan government had set up some public trust. And the contract was entered into by the trust. The other company, which was a Saudi construction company, said effectively we are dealing with the government. This trust is only an instrumentality of the government. And though the government may not have signed the arbitration agreement, we are entitled to join them to the arbitration. Government of Pakistan took a jurisdictional objection, saying we are not signatory parties. So under French law, this was the analysis of the French law done by the UK Supreme Court even, which said, therefore, all the parties had to have the common intention. And then the common intention of the party in turn means the subjective intention derived from objective evidence. Objective evidence includes the involvement and behavior of all the parties during the negotiation, performance, and if applicable, termination of the underlying agreement. Then Redfern and Hunter said effectively the same thing. 3 conditions: whether the non-signatory actively participated in the conclusion and execution of the contract. Second is, has a clear interest in the outcome of the dispute. And 3 is a party to the contract that is intrinsically intertwined with the contract under which the dispute has arisen. And Gary Born has said the same thing, that at bare minimum, the non-signatory's intention is the most important. The signatory's intention will be housed in the contract. My lords know, as a matter of interpretation of contract, one sees the contract primarily. So that intention is easier to ascertain. It's the non-signatories that's more difficult, and various tests have been evolved. And I've just for convenience shortly put out in para 12 what your lordships did in chloro controls. In para 71, if the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates, and where there was a clear intention of the parties to bind both signatory and non-signatory. Now, if this is the doctrine which our Supreme Court has squarely accepted, derived from Dow Chemicals, your lordships have said mutual intention is a requirement. Maybe now with this background, turn to the Arbitration Act. Where does it fit in under our Arbitration Act? My lords will recall only one thing. Arbitration is a statutory exception to the doctrine of restraint of legal proceedings. Section 28 of the Contract Act has an explanation saying, other than arbitration, any contract in restraint of proceedings will be void. So it saves a contract from voidness, that it has to be an arbitration agreement.
Mr. Khambhata, I would like to read your note at page 6 because you formulated it, and then you can...
Yes, may I read that? So may I read from the bottom of page 5?
Yes.
An arbitration agreement excludes the jurisdiction of a civil court, including under Section 9 of the Code of Civil Procedure, and takes away the right of a person to approach a civil court. Such an exclusion can be made either by statute or by contract only. An arbitration agreement, therefore, must satisfy the requirements of the law of contract, which is the Contract Act. Under Section 2 of the Contract Act, the following would be essential for formation of a contract. 1, a proposal. 2, acceptance of such proposal, making it a promise. 3, a promissor and a promisee. 4, consideration for the promise. 5, reciprocal promises forming an agreement. And in Vidya Drolia, your lordships held that an arbitration agreement must satisfy the prerequisites of a contract under the Contract Act. That is, in addition to Section 7, it must contain promises forming the consideration for each other. It must be made free of consent between parties competent to contract for a lawful consideration of the lawful object, and it must be enforceable by law. Now, straight away when we talk about contract and third parties or non-signatories, doctrine of privity comes to mind straight away. The third party can never enforce a contract, nor can it be bound by it. And there are various well-settled exceptions to that. Our Supreme Court in MC Chaco has said third party cannot sue or be sued unless the exceptions to the doctrine such as trust, family arrangement, assignment are attractive. Not for convenience, I'm not going to take him out, but some of the important cases we have graphically analyzed in annexures. It's just because some of the facts are usually so complicated that it's easier to do it by way of a graphic, and therefore we analyze MC Chaco, where Kottayam Bank was not a party, and it was held it's neither a beneficiary of a trust nor part of a family arrangement. It was not allowed to enforce a contract whereby members of a family had agreed between themselves to pay off dues to Kottayam Bank. Now, privity of contract and the exceptions to it, both under our law and English law, does not admit of this so-called group of companies doctrine. There is no such exception. So, the group of companies doctrine is something outside the law of privity of contract. And it seems to be on a slightly different basis. Privity of contract is a third party to a contract cannot enforce or be enforced against it. Group of companies doctrine says this is not a third party. This is effectively a party, a real party. So unless you reach that conclusion, one would fall foul of the doctrine of privity. The court has to reach the conclusion that this is a real party or a veritable party. Short of that, a factor here or a factor there is not enough. Now, may I proceed further, para 19. Arbitration in agreement in restraint of legal proceedings would be void, section 28. Specific exception is carved out for arbitration. Exception 1. Saving of contract to refer to arbitration disputes that may arise. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the disputes so referred. Therefore, two or more persons are required, and they must agree to refer any dispute which arises between them to arbitration. So the non-signatory party must come within these two or more persons. That is to say, it must be treated as a party. Short of reaching that conclusion, one can't rope in a non-signatory. And because there is, my lords know, I have not cited this, well settled, Arbitration Act is a complete code. It's exhaustive of the law of arbitration. So unless it is a valid arbitration agreement under the Arbitration Act, there's no other arbitration outside the Arbitration Act by which one can bring in a non-signatory or non-consenting party. Now, even enforcement of a contract, this is interesting in the Specific Relief Act. When we are dealing with companies, there are only two categories that have been roped in addition to parties. Section 15, which is who can enforce a contract, permits enforcement of a contract by a non-party company in only two cases. One is subpara G, amalgamation. So company A enters into a contract, ultimately amalgamates with company B, and the amalgamated company can enforce that contract. And H is pre-incorporation contracts, when promoters enter into it before incorporation of it. Again, the Specific Relief Act has no such category or residual category even of a non-signatory company because it belongs to a group and it may have been involved in something becoming a party which can get specific performance. And Section 19 is the other way around. Against whom can you obtain specific performance? Again, only these two categories. So again, I point out, I'm not for one moment suggesting that the group of companies doctrine still can't be incorporated, but it has to reach the result of a conclusion by the tribunal or by the court that this person is nothing but a party. Only the formality of signature remained. Short of reaching that conclusion, There is no way within our matrix of law that one can bring in another type of hybrid type of a party against whom or who can enforce specific performance. Now let us come to the Arbitration Act. Because in my respectful submission, the Arbitration Act actually narrows what is found in the Contract Act. And I tell my lords, 2(1)H only says party is a agreement. There's no restriction there, and there's no restriction of signatory. Can be someone who doesn't sign. 2(1)H, we've seen, does not incorporate the Law Commission's recommendation of claiming through order, but at a certain level, that's not critical to your Lordship's analysis. Because we are seeing claiming through order is a derivative character, whereas here we are trying to see who is the real party or the true party, which is not a derivative character. In a derivative character, the cause of action would belong to the original signing party, and only someone claiming through order in that very character would come in. Whereas here we are saying the third party who has not signed has its own cause of action, or there is an independent cause of action against it, not derivative. Therefore, this point is there. We've argued it, but at a certain level, my lords may take it that true order is not determinative of the answer to this question that faces the Constitution bench. Now, I've set out from paras 23 to 27 this concept of the definition of party. In para 28, of course, I've referred to the requirement of consent and the party autonomy being the backbone. As one US Supreme Court judgment had put it, arbitration is a matter of consent, not coercion. Puts it very nicely. There's no mandate of the law that you are a party. It has to be housed on consent and founded on. Without consent, you can't have arbitration, unless it's a statutory arbitration. That's a different category. Now, please see may I just show the provisions of the Arbitration Act?
Yes.
If one goes now to section 7, what we were just saying this morning, 7.1. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes. I pause here for a moment. These words describe the contract of arbitration, the arbitration agreement. Now, the following words say what the character of those disputes could be, which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. As my Lord the Chief Justice said this morning, this is the source of the dispute. And that's a nice way of putting it. The subsequent words are, where does the dispute come from? It must come from a defined legal relationship, whether contractual or not. And one can think, in fact, it fell from the bench in the morning. There are various examples. Quasi-contract, section 68 to 72, all those, quantum meruit, monies had and received, all those are not contracts, and yet a dispute could come from them. Family arrangements, partition suits, all those are disputes where there is no contract. Trust could be another area. And of course, now there is a fourth area, which your lordships in Vidya Jolia have contemplated, that even in personam disputes arising out of an in rem right can be the subject matter of arbitration. So it could be an IPR dispute where whether the trademark or the patent is validly registered can never go to arbitration. That's a matter in rem. But if there's a dispute between parties or an infringement dispute, that could potentially go to arbitration. It's an in personam dispute. Again, that sort of a dispute is not housed in a contract. It could be from a license agreement, but it could be just two parties using the same mark. Therefore, the Act rightly says that you need an arbitration agreement, which has to comply with the Contract Act. That agreement can be in respect of either contractual disputes or even non-contractual, as long as there's a defined legal relationship. Now, that's all right. 7.3 says an arbitration agreement shall be in writing, and 7.4 says an arbitration agreement is in writing if it is contained in A, document signed by the parties that requires signature, B, an exchange of letters, telex, telegrams, or other means of telecommunication including communication through electronic means which provide a record of the agreement, or C, an exchange of statements of claim and defense in which the existence of the agreement is alleged by one and not denied by the other. Now, it is going to be my submission, and I hope I can make it good, that 7.4 is exhaustive of 7.3. And I'll show from the UNCITRAL model law and from other statutes why this is so. In other words, the agreement in writing has to be in one or the other of the three forms, A, B, or C. And straight away, may I say that this itself does not exclude the group of companies doctrine. Because B, for example, exchange of correspondence. It can be that a non-signatory party has exchanged that correspondence where it is effectively shown that it's a true party.
But 7.4 may not be exhaustive of 7.3. 7.4 may be an illustration of 7.3 also.
That is a possible argument. My lord is right. But please, if my lord sees my note.
Because 7.3 says that an arbitration agreement shall be in writing. It's the norm.
Correct.
And 7.4 provides for instances
exactly.
where an arbitration agreement is.
Exactly.
Of course, there's one thing which is there, which it doesn't say it shall be deemed to be in writing if. It says is in writing if.
If it is contained. The word if is used. And something may turn on that. So I want to place before my lords the UNCITRAL model law.
But it's not necessary for us to unduly restrict 7.4 by saying that these are the only instances where an arbitration agreement will be deemed to be in writing.
I understand that. That, of course, your lordships will determine. But may I just place some material which might be of assistance to my lords in that exercise? In my compilation...
I'll tell you why.
Yes.
This was actually worrying me in the morning. 7.4b refers to an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement, right? And C then refers to claim and defense. Now, B provides an extremely limited. A is a document which is signed. B refers to only an exchange of letters or electronic means of communication. Now, there may be other circumstances where there is no exchange of letters or an electronic communication or a physical communication between the parties. Where, for instance, I'll tell you, suppose there's a measurement book in a contract. That measurement book will not fall either in terms of a document which is signed by the parties. It will certainly not be an exchange of letters. It will not be an exchange of statement of claim or defense. So there may be other conceivable circumstances in which parties may, by writing, agree to an arbitration, which is neither a letter or exchange of correspondence, nor is an exchange of a statement of claim or defense, nor is that document signed by the parties, but which may still be in writing.
I see what falls from my lord.
It could be a record of
agreement.
But it's a record of an agreement.
So long as it is a record of the agreement.
That's right.
That's why I told you a measurement book.
Correct.
So,
measurement book
so
between the
therefore,
parties.
these three instances which are prior to record of an agreement is not exhaustive. The keywords are record of agreement.
Correct.
What is a record of agreement? There are instances like exchange of letters, telex, telegrams, and other means of telecommunications, including through electronic mode, are instances of record of agreement, which could be.
And therefore, B could be
read. The absence of the word only in 4.
Yes.
Is again, just as you have the absence of the word signatory in 218.
Yes.
And the absence of word only in 7.3, in 7.4. But an arbitration agreement is writing only if it is contained. Correct. Then you would have been right. But that word only is absent.
Maybe obtained by seeing the UNCITRAL model law, which underwent a change. I'll show both. Because our act is based on the model law, and your lordships have held repeatedly that the model law is an appropriate guide to interpretation. It can be looked at. If we just see the model law as it first was in 1985, that is page 637 of this compilation. What is the equivalent provision there? And then what is the change?
I have a small doubt.
Yes, sir.
See, this expression, the real rubric which you are placing so much reliance on is consent, correctly?
Yes.
But then consent is also a little amorphous. Should it not take color from the Contract Act till it actually becomes a contract? That is, should it also definitely not constitute principles of promise?
Yes.
Which is, should it not have offer and acceptance?
Yes, I'm obliged. I'm
So
okay.
therefore, one has to see under the definition of 2E, F, G, H, I,
Yes.
leave alone J of the
Correct.
Contract Act,
My lord is right.
where a third party becoming a part of an arbitration, it needs to be concluded by the court that there is this semblance of reciprocal promises or offers and acceptance leading to an agreement.
Yes, I'm obliged.
You don't need any further.
I'm
Leading
obliged.
to an agreement, and all this could be sourced from the record of agreement.
I'm obliged. But I may I adopt that as my submission. I put it a little inartistically. My lord is
That
right.
must be there.
Yes,
It's not just saying that consent is there means consent.
correct.
What
It has to be a consent
consent can't
amounting
be
to
anything but a
contract,
consent.
which is why
Consent evidencing. Let us use this very expressions. Every set of promises forming the consideration
yes,
from each and for each other as an agreement. Promises which form part of the consideration or part of the consideration for each other are called reciprocal promises. An agreement not enforceable in law will be void. An agreement enforceable is a contract. At least offer and acceptance.
My lord.
Again, Contract Act defines offers and it also defines acceptance and how it is completed.
And an arbitration agreement has to first be a contract.
And again,
No, it may not be a
consent,
contract. Sorry.
it may or may not be a
It
contract.
need not be a contract. That is another doubt I have.
That's 7.5.
No, may I then throw a few things and I'll come back because your lordships in Vidya
The
Dholia.
contract may not
Yeah,
contain an
yeah.
arbitration.
Contract like Vidya Dholia, general observation that it's a contract, but it does not really, they have not gone into it, to be fair to the bench. The question didn't arise in Vidya Dholia as to whether Arbitration Act is confined to a contract, which is agreement enforceable by law.
Maybe see 7.1 again for a moment.
But that's not really a.
I understand. No, I mean, these are issues that will arise. I invite such questions because this is correct. It enables me also to formulate.
Good. Actually, according to me, Arbitration Act must be wider than what Contract Act.
My lord,
provides, so that you can
arbitration-
have an arbitration even with respect to non-contractual relationships.
No, of course. I'm sorry. That's why let's go back to 7.1. I'm not saying that you can't have an arbitration agreement in respect of a non-contractual dispute. That's not my submission. 7.1, an arbitration agreement
It's
has
a matter of
a
contract.
contract. But it can be, I agree to arbitrate disputes of partition, of family matter. I agree to arbitrate disputes of quantum merit.
One is what can be the subject matter of the arbitration.
Yes,
The second is whether to go to arbitration
this has to be a
is
contract.
a contract.
Has to be.
Once parties have, what you're saying is, once parties have agreed to go to an arbitration, then the context of the arbitration, the
I'm okay.
content of the arbitration
Can be much wider.
Well, it may be, as I said,
Can be much-
between two brothers on partition may be the subject.
In fact, it's not in public, it would be contrary to public policy to narrow that content.
So in other, sorry, sir. In other words, Section 7,
Yes,
you're saying arbitration, the heading is arbitration agreement.
agreement,
So you're saying it should be read as arbitration contract.
contract. Yes. And that is the basis of any arbitration. It's very well settled that arbitration is a contractual means. As I said, apart from certain statutory arbitration, which are matter of statute.
The MSME Act.
Correct. That can be different. I'm not saying that is overridden. In fact, the Arbitration Act itself contemplates statutory arbitration.
Or in Madhya Pradesh, you have a statutory form of arbitration
Correct.
for all public disputes.
Correct.
That's different.
That's different. I'm not saying that,
legislative
of course, that works. We are talking about contractual arbitration in part 1. And Section 7 deals with contract meaning the arbitration agreement has to be a contract, but that contract can allow arbitration of disputes not only in contractual disputes, but other disputes as well, as long as there's a defined legal relationship. So I'm not for a moment suggesting that the scope of the
But
agreement.
really, the group of companies doctrine is an effort to locate who is a party to the
Who is the
contract.
party?
Right. And in locating who is a party to the contract, you go beyond the signatories to the contract, where
Yes.
the conduct of the party, which again has to be evinced in writing, having regard to the provisions of Section 7, shows that there was an intention to bind non-signatories, both by parties who are signatories to the document, as well as the third parties who are not signatories.
So for example, it could be that a non-signatory has an exchange of letters, telexes, etc., recording the arbitration agreement and indicating that it impliedly that it's consenting to it. That would come within the doctrine. It would come within our Section 7. I'm not saying it wouldn't.
So suppose there's a contract between A and B.
Yes.
And C has aliened by its conduct or whatever, indicated that I affirm this contract.
Yes.
I stand by this contract.
Yes.
And how do I stand by this contract? Either in terms of the stage of the negotiation of the contract, the performance of the contract, or the termination of the contract. In which event, C has clearly indicated that, well, it is really as much a part of the contract as A and B.
I'm okay. That is my argument. So mine is really a mid path. I'm not on this side or that side. Look, someone asked me this morning, are you for group of companies or against? I said, I can't answer that question because my argument is an intermediate argument.
No, but you are not saying that there is no group of companies doctrine in our law at all.
I'm not saying.
You accept the fact that there is a group of companies doctrine.
Yes.
That this is really a legitimate extension, or it is within the statutory mandate. But the contours of the doctrine have to still comply with the essentials of the...
Yes, with Section 7 and of course with the provisions of the Contract Act.
Group of companies is one instance.
One more question. One of the interveners, one of the young lawyers argued it on this side. I think Pallav Mongia, I'll just tell you who. Why confine it only to parties who are part of a group of companies then?
That is in fact what Professor Hanushu's article also says. That it may not be confined to parties within a group. The group of companies doctrine is evolved in this manner.
They are sourcing from these statutory.
Makes it a little easier in terms of the fact that the benefits of the contract are emanating within an...
It may be one of the factors. There's no question. It may be one assistance to a person determining whether this is a real party or not. But take a totally different case, a back-to-back contract. Where the two A has a contract with B who has a contract with C. So AB is back-to-back with BC. Now A and B may not be part of the same group at all. They may be totally independent companies.
They would still be bound.
But if one could show some correspondence where A commits to C that I am bound by your contract with B and the arbitration clause in an implied way. I'm not saying the language has to be so express. Then one could say that A is also bound by that arbitration.
Irrespective of whether A and C were part of the same
group, or even whether A and B were part of the same group. Yes. Yes. So it boils down to finding a contract by conduct or consent. And one of the factors which may assist along the way is it's a group of companies.
Group of companies could then be just one of the factors, but here by conduct and consent.
Yes.
People who may not otherwise be seen as a group
Precisely.
would also be roped in.
Precisely.
So if that happens, then this group of companies doctrine could just be an element in analyzing whether they could be roped into an arbitration proceeding.
Precisely.
So the existence of a group of companies is not a sine qua non for bringing a non-signatory to an agreement within the fold of the arbitration agreement. The existence of a group of companies may be an additional factor
correct,
to show that because they were all part of one economic entity, the broader corporate group, for instance, therefore, say a parent stood by the contract which its subsidiary was entering into or an affiliate was entering into.
That may assist the tribunal or the court. But That's not the search is for finding who is the true party. Is it a true party?
It's in other words evidentiary and not normative.
Precise. And that will subserve the corporate law principle that a group structure can be devised.
I was just recalling this Competition Act Section 3
Yes.
talks about the definition of anti-competitive agreements. Just generally, I may be wrong, but I'm just sharing. It encapsulates the concept of what are anti-competitive agreements. Having said that, it gives 5 instances, which are actually cases where bid rigging, collusive rigging, and so on. So those are actually per se cases. If there is a case of bid rigging, automatically it will become.
That's right.
Like in this case, a group of companies and certain other instances will automatically be, but it has to be actually sourced to the definition of the statute to see if those conditions are satisfied or not.
Yes. The problem for why I'm raising this is, what is happening is groups of companies, you may have even a common promoter. I'll come to that later. What is happening is we have a group of 2 companies with a common promoter. One has entered into the agreement. The other is not a signatory. There are no obligations under the agreement, nothing. And they said, no, it's the same promoter. And therefore, it must be party to an arbitration. And with all the consequences. And listed entities are being dragged in. In fact, I'm appearing in a matter where it's a listed entity. It's dragged in on this ground. Therefore, there is need for some indication of what this concept means.
This concept means, again, we will have to be very, very clear about this. Consent.
Consent.
So then one has to pronounce the contours of a consent.
Yes.
So do we go back to the definition of Contract Act and then?
Yes, my lord. I would think that is necessary because.
Yeah, we will have to go to it. In every case, do we have to see which is the offer, which is the acceptance?
One would
What
have
is the consideration?
One would have to. Consideration is slightly different. As my lord knows, under our Act, it can move from a third party also. From the promisee or any other person, 2(1)(d) of the Contract Act. So to that extent, it's not such a strict that there should have been consideration. But that test has to be applied. Question is, for example, a non-signatory member of the group. What is the promise it has made? It has to be seen. It's not a promisor. It's not a promisee. How does it get drawn into a contract of arbitration?
The court has to infer from contract to contract.
Yes, that is case.
Agreement to agreement.
That will be case.
So court will only be stepping into the analysis of the agreement and then saying, I will assume that this benefit A gets, the fallout of it is actually on C, who is eventually getting the benefit. So therefore, this works as a consideration.
But there also, my lord, there are 2 ways perhaps. One is beneficiaries. If there's some kind of a trust, then there has been a standard exception to doctrine of privity. You don't need to even go to group of companies. But say there is some indirect benefit. Does that make the person a promisor or promisee just by getting that benefit? One may be able to trace the various other instruments available. But does it make it a contract for arbitration? That is a question that has to be answered on a case-by-case basis.
Some presence or semblance must be identified.
Must be something.
We don't have to get into too much of it.
Otherwise, we are undermining the whole concept of arbitration. My concern is...
Well, see, we shouldn't make it too restrictive also, Suppose A has entered into a broader agreement with C.
Yes, ma'am.
All right. C has entered into a broader agreement with A. So now A has entered into an agreement with B. C stands behind the agreement. C is interested in the success of the agreements which A will enter into with B, C, with B, X, Y, Z, because that is central to C's contract with A.
Correct.
Now, if C enters into the contract with A, conscious of the fact that the business venture between C and A is dependent in turn on the success of the venture between A and other third parties, and conscious of that, C holds out a representation that, look, I am there.
Yes, that my lord is right, but that would fall under an estoppel, a benefit estoppel, which is a different concept. And there I must tell my,
But these are all, in that sense, they're all,
Case to case.
and these are all related concepts. Therefore, group of companies is not the only point, is not the only situation in which you
Correct,
can
but
include
therefore-
a non-signatory to the
therefore, one
arbitrator.
would have to say that an arbitration agreement has arisen by virtue of an estoppel, and then the next question would be whether Section 7 covers such a contract. One may be able to sue the person on the grounds of estoppel. That you made this representation, I entered into this contract, I have suffered loss.
Therefore, Mr. Tushar Mehta had sort of A, B, C, D, E, F.
Correct. But today, seeing only our arbitration act, all those concepts can't be brought in unless they fit the bill under Section 7.
Obviously, you have to come
So
under.
so the representation has to be in an exchange of letters. It can't be oral, for example.
No, the
It can't be oral.
The question is to identify the principles for fitting the bill, because when we lay down the law, it should be, there must be some amount of certainty. So
Yes.
what is that minimum content that we
The
have?
minimum
prescribed?
content is that
Prescribed is what is important.
there must be a contract in law which is entered into by the non-signatory by virtue of his conduct. But that contract to enter into arbitration has to be established. And the arbitration agreement can be housed in a document to which it is not a signatory, because there is a record of the arbitration agreement. So simple case, A and B have a signed arbitration agreement. C can say in an exchange of letters that since I'm completely involved in the performance, etc., I accept that this is how our disputes will be resolved.
I think easier way to define
It need not sign. It could be a non-signatory party, stated.
You can say 7.3 really is the norm, that it is.
But
to be
before
an
that,
agreement.
may I just show one thing?
And 7.4 is the evidentiary burden that you have to display.
Yes, but please see the UNCITRAL
Of
model.
when it is deemed to be.
That
when
throws a
it is-
lot of light on how to read 7.3. Please just see the UNCITRAL model law at page 637 of the compilation, just for a moment. So that may assist your lordships in how to interpret this.
I was just talking to my learned brothers. We need not pressurize you to conclude today.
I won't be able to conclude. Quite
So
frankly,
no problem. We also have been asking questions. I mean, the reason we were asking questions, that helps us to regurgitate our own thoughts also aloud. And so how long roughly would you take on the 11th?
about an hour and a half.
An hour and a half. So if we start at about 11ish on,
When,
you can 12:30, you can.
yes, whatever, I'm in my lordships. Whenever, or whichever day, whenever I.
Because 5th, 6th, we have miscellaneous.
Yes, sir.
And then-
11th, my lord. Whenever, what is it?
We have
The first part of the country, one has to be here. There's no question of.
But 11th, we'll have to wrap up 11th
Yes.
because then following week we are starting with Yes.
Same-sex marriage.
same-sex
Yes.
marriage. We are starting. We'll especially fix that matter.
In fact, as regards showing judgments, I only intend showing 2 or 3. The rest I've referred to in my note, I'm not going to repeat.
Now, what you wanted to show?
Yes, please see for one moment. 637. 637.
In
of
your
the
compilation? In your compilation?
In the compilation, Article 7 of the UNCITRAL model law.
737.
Yes, 637. 637. And if we see Article 7, 7.1 is really similar to our 7.1, but 7.2 houses both our 7.3 and our 7.4 in one. It says the arbitration agreement shall be in writing. And it goes on to say an agreement is in writing if it is contained in a document. Now, please see the amendment that was made to this in 2006, which we have not incorporated in our Act. And that, my lords, will find at same compilation, page 641
That is the amendment of?
of the UNCITRAL model law, which was amended in the year 2006, but we still follow the old definition. And the difference may indicate what the original definition, which we follow, was meant to signify. So the new definition under 7 is 7.3. An arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally by conduct or by other means. Much wider. We don't adopt this definition.
Just 1 second. Can we read it again?
7.3 at page 641 says that the amended UNCITRAL is an arbitration agreement is in writing if its content is recorded in any form,
Including oral.
much wider, whether or not the arbitration agreement or contract has been concluded orally or by conduct or by other means, which also shows that the three means prescribed in the original UNCITRAL model law, which we have adopted, are the three means by which the law intends the arbitration agreement to be.
But not the only three means.
I'll leave it to you.
Mr. Kambata, you're right. I mean, frankly, there is intrinsic evidence to support your interpretation because it says an arbitration agreement is in writing if it is contained.
Because
that's a clear indicator.
If these are not the three means, then why would we list out?
I know, but we can still
Leave it to your lordship.
bypass
I'm not pressing it beyond the point. That is for your lordships. I'm just
Justice requires us not to accept that.
But just one last
It's an
thing.
evidentiary requirement.
Please see the equivalent provision of the New York Convention.
Where is that?
Page 693 of the same one. Article 2.2. Again, a much wider definition.
693.
Article 2.2, the term agreement in writing shall include an arbitral clause in a contract or arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. Shall include rather than if.
Article 3.3, is it?
Bottom.
2.3. 2.2. I'm sorry, 2.2
2.3.
at page 693.
2.2.
222.
These were all available definitions. Parliament adopted the strictest of them all in our 7.3 and 7.4, which is retained even today. And your lordships have also held, or such, I can't say held, in all fairness, it has been suggested in your lordship's judgment in both Discovery and Charan. I'll place those, not specifically decided. I'll be very clear. I cannot go so far as to say your lordships have decided this. Your lordships have not. But that is the suggestion that 7.3 is colored by 7.4. As my lord said, that's the evidence by which you prove 7.3.
One other way of looking at it is that 7.1 is actually defining the relationship in terms of defined legal relationship.
Yes.
7.1, defined legal relationship. As long as through the documents and what is specified under B, 4B, through the record of agreement, it could be shown that there has come into existence a defined legal relationship. Within the in sense that there is a relationship which is existing, which is authorized by law, not something which is illegal.
Yes.
Something which has come out of the relationship between A and B, which has an implication on C, and that legal relationship has come into existence, is sufficient to call it.
Is sufficient, provided there's an agreement that disputes from that legal relationship.
Agreement is again inferable. That's of course that's taken. Agreement is inferable from.
No, I asked myself, what if there's an exchange of letters where two parties say we'll become co-owners? That's a defined legal relationship. But they say nothing about how their disputes are going to be resolved. That the arbitration agreement has arisen. There still has to be some agreement as to the arbitration agreement.
Yes.
Okay. realized.
In Dow Chemical, they were meant you just described the claimants, Dow USA, Dow France, and the Venezuela, and I think the Swiss company. But somehow I found that very interesting. They are part of a group of which Dow Chemical USA is the parent company. The three others are the daughters and granddaughters. So expecting that the grandfather would stand by or should stand by. And in that case, the grandfather should also be liable for the.
And the grandfather had all the trademarks. Without those trademarks, it could never have been performed.
That's right.
And what is right away, because
So we'll continue on the 11th.
I'm grateful to my lord.
After Mr. Kambata, then Mr. Diwan will.
I would address your lordship.
And then we'll hear.
Whoever's there, start.
Be difficult to argue one by one.
I agree.
Both at a time.
Malas, posterity will also get to know what foolish arguments we made, Malas.
And also good arguments. But
And
nobody
of course,
admits.
Virat.
Nobody admits.
But it's we will, of course, this will be a great record for the.
No, no, you
for
will-
Yes, yes. No, no, I think it's a wonderful idea.
Truly a court of record.
Yes.
Because every word is recorded.
It should be, it should be.
Every word is recorded.
Court of record.
Malas, in fact, I can share something with you. When Malas practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about this, about the 70s. Malas, they would record everything that was said in the course of that examination, even then. So that we know, lawyers knew what was going to happen.
Gujarat has e-court, my lord, in the sessions division, sessions courts. There even our internal whisperings are also recorded.
That's very dangerous.
Videos and-
That's
hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem. But they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So.
That's wonderful. That's wonderful. That's truly
In VC
Truly
proceedings,
a milestone, I would say, Malas.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that second so that it won't
Hopefully.
overlap with one another.
So, Malas, let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
Pen drive last time ka. Yes.
what is in issue is whether
Last time ka.
the legislative party, that's the central issue, whether the legislative party in the House
acts independently of the political party. That's the central issue. Because I will, Malads, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malads, there is an umbilical cord link between them while they are sitting in the house and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malads, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Well, the bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, Mr. Sibal, therefore, that unless there is a split outside the House,
Yes.
within the political party,
Yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention. That's the law also, Mulad, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Mulad, I'm giving your lordships an example, Mulad. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Mulad, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Malad, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now, there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Malad. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Mullah, there's a problem. Supposing, all right, then let's analyze that for a minute, Mullah, since your lordships have raised the issue. Mullah, supposing there are 10 members of the legislative party in the House, right? And the merger has to take place of the political party. They belong, say, to the Mullahs, to the Samajwadi Party, right, Mullah? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore, Samajwadi Party has to merge.
But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the Speaker cannot take a decision within the House, within
No,
his
Election
constitutional
Commission did
remit on
not
whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Mullah.
How else?
Because a resolution will be passed that we have merged. And that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
not so.
Let's have a broad now framework of the facts, because
I will, Manoj.
in fact, that was our basic problem there. Unless we have a clear perception on the facts, it's very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, Manoj, may I just, your lordship, what are the issues that are going to be? I just told your lordships too.
We have to necessarily reframe the issues, because the issues which are there, which are
Yeah, it's not reflective of, Manoj, what needs to be decided. I agree entirely. Manoj, the other issue is, and that's never come up before the court, and that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Mullahs, that's one of the issues that your lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the is the powers of the Election Commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition, that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Malaj, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibal, is your independent challenge to the order of the Election Commission.
That's a separate issue, Malaj.
We can't really decide.
No, that's part of the reference, Malaj. I'm going to argue, Malaj.
Can we, how do we... He's saying...
Constitutionally, the Election Commission cannot proceed. Malaj, the split would have to happen on 21st of June. There was no whisper of a split on 21st of June.
Your contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what your lordship said. No stay, fine, Malaj, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Malaj, when your lordship sit at 3:30. But be that as it may, that's the last question that your lordships, your ladyship will have to look at. So these broadly, Malaj, are the issues that you might be asked upon to decide, Malaj, that you might wish to decide. Now, Malaj, let's go to the list of dates, because unless you have the facts, Malaj, it will be... Malaj, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sibal, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we reference order. Further.
Yes, reference order. Your lordships will have that. Order compilation, Malaj. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, Malaj, 23rd of August, 2022.
Page 28.
Page 28, Malaj, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, Malaj.
28.
Your ladyship has it? Justice Shah, Malaj?
Yes.
May I, Malaj? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Malaj, I've already argued that. So Lordships Mullahs have deferred your Lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the Speaker? Actually, B and C are together, Manoj. They are interlinked.
Per se cases.
Yes. The language is somewhat, Manoj. D, Manoj, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Manoj, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Manoj, if the decision of a Speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Manoj, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, Malaj, F, I think is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the Election Commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the constitution does the word political party is referred to, except in the 10th schedule. Because in the constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Millards, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then, I, what is the extent of discretion and power of the governor to invite a person to form the government and whether the same is amenable to judicial review? Well, it's governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Millards, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Millards, in the early hours of the morning, gave an oath, to the oath of office, Millards, made somebody a chief minister, and by the early morning, Millards, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Millards, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Millards, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
Yes, A. PDF 108.
Written submissions on the petition.
Written submissions, no? Yes. You are referring to written? Yes, yes, yes. Not additional written submissions. Not additional written submissions. A, madam. A. Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I
So
said that
let's
already.
sort of structure that so that it lends some clarity to.
Well,
submission to
let us do that in the evening. Well, that would be much easier for us.
No difficulty.
If your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll give some
Also,
agreed
sit down,
issues, Malad,
in
yes.
the evening and give us some agreed issues which will arise.
Because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take? So that then we can restrict them as well and to certain time.
Malad, this side, Malad, will take 3 days, Malad.
Mr. Sibal, how long would you take? About 3 hours or so today?
No. Malad, I'll take much more tomorrow too.
Mr. Sibal, we'll have to have structured arguments.
All right. It will be structured, Malad. I'm not going to repeat myself at all. Your lordship knows I myself, Malad, reduced,
After Mr. Sibal, after you conclude, Dr. Singhvi will
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath. Yes. And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you...
we'll try that, Manoj. We'll try that. No issue, Manoj. We'll certainly try and speed it up. I just think, Malad, your lordships may have questions yourselves.
Of course. If we find that, of course, there's a little change in the time schedule, we can certainly do
Then, Malad, your lordships will also have to decide on the NABAM reference at some stage, what your lordship wants to do, because that sort of opens up another...
So we'll look at the list of dates?
Yes, Malad. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position, as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, if there is an elected government, the attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to Your Lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant. If there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordships, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, October 2019, elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Aghadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November?
Yes.
Supreme Court's order?
Yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then it's mentioned there. Anyway, April, May 2020, governor has been at loggerheads with the MP. 2511. Oh, 2511, Sunil Prabhu. Now this is important. 2511, Sunil Prabhu is appointed as chief whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship may actually, if Your Lordships don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right, all right.
Break of
Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackre's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for the Legislative Council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has along with certain others delinquent MLAs of the Shiv Sena gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21/6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your Lordships has to constitutionally consider. So a faction, which is the legislative party, decides that I will change the whip. Constitutionally impermissible. Then, the decision, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, in the meantime, somebody had to be appointed, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shiv Sena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM? CM Malaz is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. On 23rd of June, Sir Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly Disqualification on Ground of Defection Rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June 2022. On 25th of June, the National Executive Meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of the original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Party to submit their written submissions up to today, today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here, as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to this, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. There was nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority, Malaj. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, Malaj, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed, Malaj, on a disqualification petition, that no. If a petition is filed, you can file your reply after 10-15 days, Malaj. In the meantime, the minority gets in touch, Malaj, with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced, Malaj? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, Malaj, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, Malaj, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, Malaj, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shiv Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, Malaj, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide, given these facts? Then 28th of June, Malaj, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the Assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this Honorable Court seeking a stay. So, as we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given our thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the Deputy Speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceeding of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing with us. Proceeding of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality, because the judicial order itself says that it's subject to. So you cannot say, now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned. Because he knows the writing was on the wall, having given legitimacy to those who... Then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malats, one second. Yeah, I'll take it. Then, Malats, 1st of July 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Sawant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10th scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as Chief Whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as Chief Whip of SSLP, issued whip to the members of SSLP regarding the election of the Speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip and vote for a BJP candidate against the Shiv Sena member? There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
How many votes did the rival candidate poll that day?
sorry,
Of July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
That's all. We are not Mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, Mullahs. Correct.
But therefore, if these 39 are excluded from 164,
Mullahs,
will they still have 125?
I am not Mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, Mullahs. I'm not saying, Mullahs, whether he would have. Supposing, Mullahs, all of them are disqualified, because on that particular day they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
Yes.
from the 164,
Yes.
they're still down to, they still get 125, right?
That's right.
Your Lordship is right, Mullahs. I am, at the moment, Mullahs, I am not challenging. At the moment, Mullahs.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
Trust vote happened on the 4th.
Because Mr. Sibal, you don't
happen on the 30th, Mullahs.
Right. You don't, ultimately, you don't face the trust vote.
Yeah, I don't, Mullahs. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the speaker, trust vote, whatever. All that is challenged. Mullahs, the question is, at the moment, Mullahs, we are dealing very, very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, Mullahs? That these people were able to topple the government without the disqualification petitions having been decided. There was an elected government, Mullahs, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, Mullahs, your Lordship holds by these actions, which are uncontroverted, that they disqualify themselves on both counts, 2(1)A and 2(1)B. What will be the result? And if your Lordship holds otherwise, let's assume, against me, then this will be, Mullahs, you have given them a model to topple every elected government.
But Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held on the 30th.
Yes.
Now, you resign, right, on the 30th.
Yes.
And therefore, is this not really clearly an indicator that even excluding these 39...
That's all right. The speaker could have been, Mullahs. Yes, I'm not disputing that, Mullahs. I'm not sure what the arithmetic is. Half 145 is the halfway mark, Mullahs.
What my Lord the Chief Justice
You deduct 34, you are below, Mullahs. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord's 288 was the total.
Yeah, the number. Just give it.
We'll just give you the
strength of the assembly. The actual.
Just 1 second.
Yes.
Total strength of the assembly.
288.
That was there from Mr. Sibal's chart, which we saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second. Just one second. Total strength
So
of the
half
assembly.
mark would be 100 and
Just
1 second.
Yes.
164.
45.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those...
Just 1 second.
249, half of it is?
249 and then...
And the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed.
Plus, there were only 16 disqualifications.
Yes. Plus, on